Greetings, everyone. My name is John Gannon, and I'm likewise an attorney with the Division's Bureau of Municipal Finance Law. My presentation today will cover 5 appellate cases, and I'll briefly mention 2 more that the State Supreme Judicial Court recently decided within the last 2 weeks. Now, the first case I'll touch on concerns a municipal labor and employment case. The second 2 cases concern regulation of the burgeoning cannabis industry, along with brief mentions of the 2 newer cannabis cases, and the last 2 cases involve issues concerning municipal invocation of eminent domain property taking authority as provided by General Laws Chapter 79. Now, the first case I'm going to talk about, Town of Brookline versus Gerald Alston. The issue presented in this case is whether the State Civil Service Commission can consider evidence related to a racially hostile or retaliatory work environment in its consideration of whether the town of Brookline had just cause to terminate a tenured civil service firefighter. Now, this fact-extensive case, I will read through the issues and discuss the final conclusions. Like I said, the facts are pretty extensive. But in this case, the town appealed a decision of the State Civil Service Commission, ruling that the town had acted in bad faith in unjustly terminating Gerald Alston, a firefighter, and awarding reinstatement with back pay. Now, Alston, a Black firefighter, had received a voicemail from a lieutenant superior that concluded with a racial slur, which the lieutenant later claimed it was not meant to refer to Alston. Now, eventually, Alston filed a formal complaint with the then fire chief, who, after meeting with Alston and other town officials, moved the lieutenant to another fire station away from Alston and told Alston that the lieutenant would never be promoted. Next slide, please. The select board of the town of Brookline conducted a disciplinary hearing for the lieutenant, and contrary to the fire chief's recommendation of harsher discipline, including that the lieutenant not be promoted, approved only a lesser 42-hour unpaid suspension. The town later made a series of fire department promotions, including promoting the lieutenant to temporary fire captain and then to full captain. A fellow firefighter posted on a union blog a derogatory message referring to Alston and prompted other series of hostile actions. Eventually, trainers from the Massachusetts Commission Against Discrimination conducted discrimination prevention for town employees, and the town circulated an anti-discrimination policy. Next slide, please. Alston eventually filed a complaint with the MCAD, alleging that the town had discriminated against him by promoting the lieutenant. He later amended his complaint to include claims alleging systemic retaliation from his colleagues within the fire department after he had initially reported the voicemail. Eventually, Alston withdrew his MCAD complaint and filed a civil action in state court with the same charges. At some point thereafter, Alston started receiving more issues that he considered to be retaliation. For example, he came to his assigned fire engine seat to find the word "leave" written on the door. He also reported feeling shunned by his fellow firefighters and began expressing fear that they would not have his back during an emergency fire situation. Next slide. In response, Alston allegedly made comments to superiors that were perceived to be threats of workplace violence. He was placed on paid leave and met with a town-hired psychiatrist. The town hired another psychiatrist to evaluate Alston. She reported that Alston could return to the fire department, but with a plan to reduce his stress. The recommendations that were made for Alston's return included mental health care, stress reducing workplace accommodations, and random drug screenings. Next slide. Eventually, town council contacted Alston's attorney about the steps that Alston would need to take to return to work, including the required drug test. Alston later missed the drug test and his paid leave was terminated due to noncompliance. Now, the town later allowed him to be placed on paid sick leave, which he subsequently exhausted. Next. Now, the original lieutenant who made the offending remark now claimed that Alston besmirched his name in complaining about the voicemail. And other fellow firefighters spoke about a narrative fabricated against lieutenant. When Alston failed to appear for evaluation, the select board voted to fire Alston. Alston appealed the decision to the State Civil Service Commission, which upheld his termination. Alston appealed the Civil Service Commission ruling to Superior Court. Next, please. In the proceeding under General Laws Chapter 30A, Section 14, the Superior Court judge vacated the Civil Service Commission's order and remanded it to the Civil Service Commission for a full evidentiary hearing. Now, the Superior Court judge, interpreting civil service law, held that, quote, an employer lacks just cause if a termination would not have occurred but for the employer's racially hostile environment, maintained in violation of basic merit principles, unquote. The judge also reasoned that an employer has no right to demand proof that an otherwise fit employee can perform job duties in a racially hostile environment, and remanded the case back to the Civil Service Commission. Next, please. On remand after a hearing, the Civil Service Commission concluded that the town lacked just cause to terminate Alston and ordered his reinstatement with back pay. The town appealed the decision to the Superior Court, which upheld the Civil Service Commission's findings. On appeal, the Supreme Judicial Court considered the town's claim that the Civil Service Commission exceeded its authority by considering claims of discrimination that the town asserted must instead be addressed to the Massachusetts Commission Against Discrimination pursuant to General Laws Chapter 151B, the state's anti-discrimination law. The Supreme Judicial Court reasoned that Chapter 31 Civil Service Law's fundamental purpose is, quote, to ensure decision-making in accordance with basic merit principles, unquote, assuring fair treatment to all employees, including assuring constitutional protections. Next, please. And the Supreme Judicial Court stated that the Massachusetts Commission Against Discrimination does not, in fact, have sole authority to consider fair treatment of all employees regardless of race. The Civil Service Commission can also determine that an employee has been subject to racist and retaliatory acts by an employer. The town next argued that Alston's prior filing of a complaint with the MCAD, followed by Alston's later filing a court case with the Superior Court, should bar Alston's claims of racial discrimination. The SJC concluded that the prior filing was no impediment to this matter, as it involved a Chapter 151B issue and not a civil service matter. The town finally argued that the Civil Service Commission lacked sufficient evidence to render its decision invalid. The Supreme Judicial Court held that the Civil Service Commission, in fact, made proper findings and sustained the order for back pay for Alston. Close.